Good morning, Judge. Good morning, Commissioners. My name is Melissa Peralis, and I am the attorney for the residents group known as Environmental Protection in the Interest of Caldwell County, or EPIC, and that's who I'm representing here today. I want to thank you for the opportunity to present on this host agreement. Now, before I go into my presentation that I've prepared for you today, I want to explain my intentions here. I'm on the agenda to comment on the proposed host agreement, but it's not my intention to explain how to make it better, nor is it my intention to advise on a negotiation strategy or even a litigation strategy for that matter. By now, I think all of you have seen an annotated copy of the proposed host agreement. I have a copy here that has been circulated pretty widely, and it's been circulated for probably about a year now. It's pretty comprehensive. Those comments are pretty extensive, addressing various provisions of the host agreement, and so I don't intend to rehash that. But I will highlight the various reasons for supporting mine and EPIC's request to deny the host agreement. So, the host agreement. As I mentioned earlier, I'm not going to go into all of the provisions. I just wanted to highlight a few. Basically, the host agreement and its terms would transform the county from a regulator who can currently protect its residents by enforcing the permit provisions that's already authorized by state law. It would transform the county from a regulator to a disadvantaged joint venturer with 130 Environmental Park. The county, though, would have no management control over this joint venture and would have no share in all of the profits. So one legal issue to consider is whether this host agreement as it's currently drafted is whether it's legal. I've included here a quote from a Texas Supreme Court case suggesting that, in fact, the way the host agreement is currently drafted is not legal. The host agreement would basically give 130 Environmental Park contractual authority over the decisions of future commissioners' courts, and that's what makes it illegal. Here, the Texas Supreme Court has said that powers conferred on governments for public purposes cannot be bartered away. Government entities cannot cede away such powers through contracts with others so as to disable them from performing their public duties. Something else to consider is that the way the host agreement is drafted, the county basically gives up everything right now up front, and so 130 Environmental Park gets everything it wants up front, but the county doesn't see the benefits till years down the road. So basically, the county would be giving up its legal right to participate in a contested case hearing and to oppose the permit, or to maybe even try to get a more protective permit in place. And in exchange, later on down the road, several years from now, it might be granted some concessions. Moreover, 130 Environmental Park can terminate the host agreement before the county has been granted anything. The way the host agreement is drafted, it says any determination or action by a government or court that materially impairs the ability of 130 Environmental Park to operate the landfill or perform its obligations under the host agreement, or, in its opinion, if the landfill cannot be economically operated, 130 Environmental Park can terminate it. So this basically gives a whole lot of discretion to 130 Environmental Park to terminate this agreement if, for instance, the landfill cannot be economically operated in its opinion. Further, the host agreement exposes the county to potentially high expenses. The county would be obligated to participate in a suit or a contested case hearing to defend 130 Environmental Park from claims that challenge the landfill. In addition, if there are any future disputes regarding the host agreement, or if it becomes necessary for the county to force 130 Environmental Park to comply with the host agreement, the county would have to expend its own resources to litigate a lawsuit, to have their attorneys sue for compliance with the agreement. And I have a little bit of experience with this. Our firm represents Caldwell County. They entered into an agreement with a uranium mining company. The uranium mining company didn't perform in accordance with that agreement. They would argue, that is, the uranium mining company would argue that they just had a different interpretation of what the provisions were in that agreement. And so we ended up in court, and that county has expended substantial resources just to try to get the uranium mining company to comply with that agreement. Now, I was present a couple of weeks ago during the presentation that was made by Green Group Holdings regarding the proposed host agreement. And what struck me about that presentation was that so many of the so-called concessions that were being offered to the county really weren't concessions at all. Some of the provisions or concessions that were talked about provided nothing of value to the county, or offered something to the county that it already had. So for instance, 130 Environmental Park agrees to limit its footprint to 250 acres. This is already what the footprint is in the permit application. In addition, this piece of property, this site, is kind of unusual in that it has floodplains all around it. I think I have a picture here showing that you've got a lot of floodplains in this area. So I mean, it would be pretty difficult to expand the landfill laterally without getting into a floodplain. There was a proposal for a 250-foot separation distance between the footprint and site boundary. That's already in the permit. And again, you have the floodplain that makes it so that 250 feet, it makes sense. You were also addressed with terms regarding financial responsibility. Well, 130 Environmental Park already has to provide financial assurance. That's already in its permit. So basically, 130 Environmental Park is just agreeing to comply with the law. As I recall, Green Group Holdings represented that by signing a host agreement, the county would have some enforcement authority. Well, it might have some enforcement authority over the host agreement. That is, it could file a lawsuit if necessary to force compliance with the host agreement. But the county currently, under state law, already has the authority to enforce a permit, to enforce solid waste regulations and solid waste statutes. And in fact, it can step into the shoes of TCEQ and take on any enforcement actions that the TCEQ is authorized to take on. There was some talk about property value protection. Again, the way this provision is worded, it allows 130 Environmental Park to submit its own appraisal, which can then be averaged with another objective appraisal, bringing the average to below market value. I mean, that's just the way the provision is worded, and that's the way it could be enforced. Other proposed concessions that were offered to the county can be described as of questionable benefit or even contingent. So basically, after the county has, the way the host agreement is worded is that after the county has entered into the agreement, it has to pull out of the contested case hearing. It can no longer oppose the landfill permit. And so the county will have given up its legal rights. It will have performed its obligations, and yet 130 Environmental Park can terminate the contract without performing its own obligations if, in its discretion, it determines that a governmental action prevented the landfill from being economically operated. In addition, there's been talk about the money or the tipping fees that would benefit the county. Sure, there is a provision that allows the county to share in those tipping fees, but that provision also gives 130 Environmental Park a whole lot of discretion in how to determine what sources constitute tipping fees. And in fact, it could arrange its affairs so that its main source of revenue is from some other source other than tipping fees, thereby making its tipping fees below the threshold that triggers payment to the county. Furthermore, the obligations of 130 Environmental Park, especially when it comes to the tipping fees and host fee obligations, those don't kick in until all of the appeals have been exhausted. If the county pulls out of this contested case hearing, I can assure you EPIC is going to stay in. If a permit is issued, EPIC has a right to an appeal, and that appeal can go to district court, the Court of Appeals. It could even go to the Texas Supreme Court. That appellate process could take years. In the meantime, once the permit is issued, 130 Environmental Park could immediately start constructing and operating its landfill. That means that it could operate a landfill in Caldwell County. Appeals could be going on for years, and there's nothing that requires 130 Environmental Park to start paying tipping fees to the county. And in fact, this happened in Guadalupe County, this exact procedure that I just spelled out. There was a series of appeals that took years to resolve. The landfill company, that in that case it was Waste Management, had already started accepting waste, and there was no obligation to start paying Guadalupe County because the appeals process had not been fully resolved yet. And finally, some of the concessions that have been offered by Green Group Holdings I think are really more in the nature of a threat rather than a concession. So basically, one of the promises that was made was that if you sign this host agreement, we'll limit the types of waste that we'll bring into the facility. We'll keep certain wastes out, such as coal ash, sewage sludge, or out-of-state waste. But the truth is that they could do that now, even without a host agreement. They could go to the TCQ, revise their application, revise their permit request, and say, we agree to limit the types of waste that we are going to accept at this facility. Even without a host agreement, they could go and seek that as a permit provision, which you would then be able to enforce. So this isn't so much as a concession as it is a threat. What Green Group Holdings is basically saying is sign this host agreement or else we might and maybe will bring these types of waste into your county. I know that resources and money is a concern for the county, and I can't promise you that you're not going to have to expend resources. And in fact, what we've seen in Waller County is that they've had to expend more than they expected because of this inaccurate information. In fact, if Green Group Holdings gets its way, it will be able to go back, redesign the landfill, come back to the contested case hearing process, start it all over again, start the discovery process all over again, and of course that's going to drive up expenses. And we're hoping that that's not what's going to happen, but it is possible. Or extreme types of weather events. That's just another example.
Any other questions?
Also, you said that at any given time, Green Group can stop the compensation, the monetary compensation to the county in case of any, if they're dissatisfied with any action from the county.
Right. So the way that it's worded, the language is pretty loose. It says that if it cannot be economically operated, the landfill can't be economically operated because of some actions of the county, then they can terminate the agreement. So what does that mean? I mean, if the county decides to enforce some of its existing ordinance, what if the county decides to enforce its development ordinance, or the Green Group Holdings still has to come to the county for a construction permit? What if the information that's included in their materials is insufficient and doesn't support issuance of a construction permit? Your hands would be tied. Either you would have to grant that permit anyway, or if you didn't, arguably you would be interfering with the economically beneficial operation of the landfill, and you could be in breach of your agreement.
So the bottom line is once you sign, your hands are tied.
Right. You have to support them. That's if you sign the host agreement the way it is, correct.
Any other questions? Thank you, Ms. Peralis.
Thank you.